And just to kind of comment on, I think what we saw today at the hearing is it revealed a very interesting type of candidate. When you think about how he made some comments that his dissents were really more for just guidance, to be a good read. It's almost that I think he's more qualified, without question, to be a law professor. And he's certainly less qualified than someone like Hector LaSalle. His administrative experience to oversee a $3 billion budget, a court system that's larger than most countries, about 95% of the countries in this world. His administrative experience is case management at Cravath, Swaine & Moore, where he was a partner. And Cravath represents clients like Israel. They have countries, seriously, that are clients. They have top 10 Forbes corporations, monsters, multi-billion-dollar corporations. So in this litigation, he actually admitted that he had never tried a case to verdict, but claims to be a corporate litigator. That's his administrative experience, overseeing a case file. And that is supposed to be adequate. Yet we have someone like Hector LaSalle, who is the presiding judge in the Second Department, the busiest appellate court in the United States. He has reduced caseload significantly. He had diversity hires in higher ratios than have ever been seen on that court. So he was not qualified, according to our colleagues across the aisle. But Judge Wilson is. Judge Wilson, the same guy who, and we saw it in that footnote I commented on as well, wanted to release a civilly confined pedophile and thought it was appropriate to put pop culture music lyrics in the decision and in his dissent that equated, I want what I want when I want it, the pedophile's statement to rape a child, equating that to a Beatles song or an operetta. And quite frankly, the arrogance of that just blows me away. The high thinking aspect of someone who should be at a law school, I get it. That's something where you can have these intellectual exercises and say, wow, that's neat. Maybe elephants should have the opportunity to petition the court for habeas corpus rights. It's not a field or not a forum for that type of conduct at the Court of Appeals. I can tell you quite frankly, because that's real life. That's not a law review. That's not some sort of a think tank. That is clearly real life. And when we see on the Regan case, this was a toss-up. It wasn't as if there were a hard black line rule that in the event the prosecution doesn't come forward with their case after being charged in 6 months, for example, in many cases, it's automatically dismissed under speedy trial. This was pre-charge delay, not outside the statute of limitations. I mean, it's very nuanced, but there was no prejudice to the defendant. He was out of custody. He raped his friend's girlfriend. He went to trial, presented his defenses, and 12 jurors unanimously convicted him of rape in the first degree. The appellate division affirmed, and then Judge Wilson saw fit, based upon a hyper-technicality, and as you also saw in Judge Singas's dissent, she was a DA almost her entire adult life, not just a line prosecutor, was the DA overseeing a large office. She said there's absolutely nothing in the law that required that case to be overturned. So this is an ideologue that we are now putting forward who has zero administrative experience to run the highest court in this great state. So I think it's a testament as to possibly a budget deal, really, quite frankly, to the fact that they care more about their redistricting case than they do about real victims in the real world. Not in a hypothetical, in the real world. And quite frankly, it's shameful.